Well, the impact of the judgment is technically, yes, it's true to say that which is confined to the parties of the case, meaning that the court upheld the decision of the minister to impose restriction on Herald. But don't forget that this decision also declares and clarifies certain rights. So that is the problem with this one. So even though the judgment of the Court of Appeal in this Herald case is merely declaratory, declaring the right, but it explains certain provision. And this is, I think, the problem with the decision. So while it's true to say that the decision is confined just to Herald and the decision of the minister, but the wider repercussion, the ramification cannot be underestimated. And that is why we come across with the assurances and the statement made by the government ministers, Joseph Kurup and Abang Junaidi, who obviously tried to limit, to calm down the anger in Sabah and Sarawak, which I think is a bit of no effect, because whatever it is, if the government is really serious about limiting the effect of the decision, then they have got to make it clear through amendment to the act, whatever, or simply, the minister revoke the decision. Otherwise, the matter would become, talk of the town. And I think, pardon? Yes, as I said, technically it just binds the parties concerned, the minister and the publishers of the newspaper. But one cannot underestimate the wider repercussion, because the court also in this case, and in fact in the High Court, declares the rights and the provision of certain provision in the Constitution. So in other words, while it is true to say that the direct impact just limited to the parties concerned, one has to remember that being declaratory on a certain aspect, then I think the Sabahan and the Sarawakian have every right to become anxious and unhappy, and in fact angry. And this is indeed why you come across statement by ministers to come down and apparently sought to kind of clarify and to minimize or do some damage control.
Yeah, justified or not, the anger or the...
Of course justified, because now we're going to the decision itself. The problem with this decision is that it limit, or rather it interfere with the way religious individual and religious group exercise their religious right, which I think is wrong, because in so doing, the court has, I think, assumed this kind of public disorder and so on without any clear evidence. And one has to remember that linking provision, or rather trying to read, or rather trying to subject fundamental liberties provision to Article 3 is highly questionable, and I would say wrong, because that has to be done by the Constitution itself. The judges cannot assume the duty to limit the Constitution when the provision itself is silent on it. The only link that we can see in the Constitution is that we can find the Constitution is, for example, the link between Article 150 on emergency and 149 on subversion, which suspend or limit certain rights under a provision under fundamental liberties. So I think in this case, the court was wrong in reading the provision in accordance with Article 3, which basically, to my mind, is just there to declare the essence or the character of the federation, nothing to do with the right. So, and one has to remember that even Article 149, that has been there to limit or suspend certain right, does not interfere with religious right. In fact, we can say that under the Constitution of Malaysia, religious right has been considered supreme, because Not even Article 149 has been allowed to limit the exercise. The exercise of religious freedom, except when it is, there is this issue of disruption or rather prejudicial to public order. But that one has got to be proved. One cannot assume that.
The very premise of the judgments
It's wrong. So this is where I think it is fine. For the court to uphold the decision of the minister or the restriction imposed by the minister. But I think what is problematic with it is it did in such a way that it distorted the constitution. To my mind, they can uphold the decision or rather the restriction imposed by the minister without manipulating, without distorting the constitution. That is the problem. And now we have got another problem. So instead of solving a problem, the court in this Court of Appeal, in this case, is creating another problem. And which is why I think it's quite understandable for the past few days. People have been talking, even in Sabah and Sarawak, who are normally quiet on this, and given the result of the general election, I think they kind of accepted it. But somehow with this decision, they have somehow, disrupted the so-called peaceful situation that we have got.
So should be how the decision? When they talk about conflict,
I don't know, but looks like that the government is panicking now. Hence the statement by the minister and the deputy minister. And who knows, after this, the federal court would overturn or would reverse the decision, but damage has been done. So that's it.
Also, the three judges, the three judgments. So who's the more?
Well, I'm basically the same, because I think one could see the major theme in the judgment, all of them, the three of them. They see here that Islam is under threat. That is a fact. And they are using Article 3 to assist the restriction that is based on Article 11. But I'm not really impressed. I find it hard to accept Clause 4, because Clause 4 is about the propagation of religion other than Islam to Muslim. In this case, I don't see any relevant, because after all, Herald is not circulated widely among the public. It's only circulated among Christians, and I don't see the relevance of Clause 4 from Article 11, that is basically meant to protect Muslims from being subjected to this propagation of other religion. It's not justified. That's why the provision quoted or rather used by the Court of Appeal in justifying that decision I find it questionable. That's why I call it startling, and some even say it's dangerous precedent.
Are Muslims generally stupid enough, maybe, or confused enough to believe differentiate Allah in Christianity or Allah in terms of Muslims? Is that why the government have to intervene, or the court have to intervene to
Well, I'm not sure as to why the government suddenly, appear to become kind of a born-again Muslim. Because if you look at some of the perhaps recent cases, for example, the case of Mia Tukar Rahmat in 2005, the government couldn't care less about even the right of Muslims to practice their religion. In that case, a poor young boy was humiliated in public and was expelled from school for putting on turban. And strangely enough, the government appealed the decision. The High Court that gave the judgment for the poor boy, and the government appealed the decision. The Court of Appeal overturned the decision and was affirmed by the federal court. So perhaps one has to see this Herald case together with what the government actually did in the previous case. In other words, if you're talking about religious freedom here, I think not just the minority that is now under threat, but also I think even the majority, among the majority, it's not entirely safe. We have come across this discussion and unnecessary adverse publicity to Shiite teaching. The problem here is that this issue is not being discussed properly. So you could see that the way discussion is being held is kind of being focused into a certain direction, involving the official, rather the agencies. You find the issue being dealt with by during the Friday prayers, during the sermon, by the sermon. So this is the sort of I think threat and tension within the community. So looking at the issue, I mean, as a whole, I think it's fair to say that not just the minority that's not under threat, but also, unfortunately, even within the majority, I mean, a certain section of the community, the Shiite, and to some extent, some so-called Wahhabis. So I think this is a problem. And of course, you have got sometimes interpretation, Sometimes the muftis hand down a certain fatwa that favor a certain interpretation. So in other words, not just the minority that who could claim that they're being persecuted.
If happen, is that we put in hypothetical
Situation.
For example, if they bring it to court, so perhaps court will favor the so-called mainstream or.
Well, that has to be yet to be seen, because despite the fact that the religious freedom is, I would say, to some extent, is absolute and cannot be interfered with, but under the Constitution, you have still got this rider, that is when public order and so on comes under threat, when the exercise is prejudicial to public order, then
but the premise
that's the end of it.
In one sense, because we don't think Shiite, for example, is a threat to Sunni.
And this is the problem.
Wahhabi,
Who to determine public order and security? Is it the absolute right of the authorities? Can the court examine the grounds cited by the minister? Because, in most cases, this Harold case is another example where the court just went along with the government. They just take the government's version, or rather the government, interpretation of the issue on face value. So they are not prepared to go beyond that.
Looks like courts either behaving like a parliament.
Yeah, that is why I said the court is very much under this wartime kind of thing. They just go along with the government, with whatever the government says. If the government says that certain thing cannot be done because it is prejudicial to security, then that's it. The court is not unwilling to go beyond that.
But even though without any.
Yeah, even though without any concrete evidence. So that is the problem now.
I mean, whatever government
authorities
propose, their media particularly, repeat it.
So that render the whatever guarantees under the Constitution meaningless, because if you have got this provision as the last rider to naturalize or to everything, then there's no point having guarantee in the first place.
Can we say in more partial words, it's a subversion of judiciary again? I mean, subversion. I don't know.
I have to say that Malaysian judiciary has not been independent from day one. In other words, it's not entirely, it's not assertive as for example, judiciary in the US or in India. Even though some people say that we used to have first-class judiciary, but if you look at the history and the decision handed down by the court since 1957, I think in situations whereby you have got a critical situation, the judges more often than not chose to side with the government.
I guess in conversion cases, a few of them, we're having this kind of law. I'm not saying that the only problem they are siding with authorities or government or ruling parties, but also the hesitant of the judges to respond to the issue. For example, the conflict between Sharia court as well as civil.
Well, one has to bear in mind that judges being appointed by the executive elsewhere, not just in Malaysia. So here we are, a situation whereby you don't see, or rather you don't see the potential, rather the, rather the prospect of being or having a court as the protector of your right.